common things that I see are, one, property damage. A lot of times excessive items and clutter inside a unit can damage the property. Two, violation of applicable housing and safety codes. Those include things such as blocking ingress, egress, or windows. And three, potentially having pests. A cluttering or a hoarding situation tends to attract rodents, potentially fleas and bugs, and even bed bugs. And four, disturbing other tenants in the building. A lot of times, hoarding situation can create odors or other offensive items or things that bother the neighbors or other tenants in the building. Yeah, so generally the important thing with a hoarding situation is that hoarding is a recognized disability. And with that comes certain obligations under fair housing laws. And that requires that an owner must reasonably accommodate that person's disability. So while a hoarding situation may violate various laws, it may violate the rental agreement, it may create a nuisance and create a basis for an eviction, the landlord must realize that he must first comply with the housing laws, which require the landlord to provide a reasonable accommodation for a person with a disability. Now, in a hoarding situation, that may mean things such as allowing the tenant more time to correct the situation and clean the unit. It may also require the landlord to allow the tenant to do things such as maybe have for instance, a dumpster or an additional trash can stored in a common area where things may not otherwise be allowed to be stored, in order to allow the tenant to remove some of that excess clutter. So again, the most important thing is that the landlord comply with fair housing laws when dealing with a hoarding tenant. So generally, again, you're dealing with a disability, and oftentimes time is a significant element to allow the tenant sufficient time to rectify the situation. And there's no specific notice or form there, but if the situation is not rectified and there's nuisances or lease violations or hazards that are created, then the landlord may be in a situation where he or she can evict the tenant, and that would require certain notices. Generally, a notice to cease, a written notice to cease, is a requirement before an eviction can take place. And what that means is the landlord must formally serve the notice with generally a 7-day notice to cease engaging in the offending conduct. If the tenant does not comply, then the landlord can serve a more formal eviction notice, such as a 3-day perform or quit notice, or possibly in a nuisance situation, a 3-day quit notice. So those are the two formal types of notices, and once those notices have run their course, if the offending conduct is continuing, then the landlord may actually have a basis for an eviction. Yeah, so a reasonable time is really very subjective and on a case-by-case basis. If it's just a traditional hoarding scenario where other tenants aren't complaining, there doesn't appear to be a real health or safety concern, well, certainly in that situation, more time would be reasonable, probably. In a situation where there's offensive odors, or there's very clear housing code violations that are creating a real health and safety hazard, then a shorter time period. So for instance, maybe in the first scenario, a month or even more time may be reasonable. Under the second scenario, perhaps a much shorter period of time may be reasonable. But again, it's a case-by-case basis. And with regard to the notice periods, those are generally set. Like I said, there's a 7-day notice to cease, and then a 3-day perform or quit notice. So those notices are set by law, but that doesn't prevent the landlord from giving the tenant more time as an accommodation for that disability, depending on the circumstances, in order to cure that violation.